up to my opposing counsel.
Yes, Your Honor.
Okay, let's go on the record on cause number DC 208948, Andrea Valencia versus Danny Blackburn. Counsel, make your appearances.
Thank you, Your Honor. Sean Hashemi with Chalaki Law. I represent plaintiff in this matter, whose name is Miss Andrea Valencia.
Stephanie Rima, attorney for the defendant, Danny Blackburn.
All right, let's proceed.
Thank you. Your Honor, before I proceed with the motion, one of the exhibits that we provided to the court was a video, the dash cam video from the investigating police officer. My office did confirm that that the video had been downloaded and that it could be played. I just want to confirm whether or not you've seen the video or you've had.
I haven't. Why don't you go ahead and play it? I can let you share a screen.
Okay, perfect. Your Honor, before I start with respect to the facts and the arguments, I just want to bring it to the court's attention that this is not a full summary judgment motion. This is a personal injury case. The only motion that we have filed, and that's before the court, goes to the first. This is a negligence cause of action, Your Honor, that we have brought against defendant. The only elements that are considered in our motion and the only order that we are asking the court for is as to the first two elements, the element of duty and also breach. We are not seeking an order on proximate cause or actual causation and or as to the damages. What I also want to bring to the court's attention before we proceed with this motion is that in this trial, my opposing counsel and the defendants have not alleged any contributory negligence. They initially did. They amended to remove it, and there is no affirmative defenses of act of God or a sudden emergency or any others regarding that would negate the duty and or the breach and excuse as to a violation of a statute and ordinance or that would go to the duty. And so I just wanted to bring that to the court's attention that the pleadings are on file with the court. I would like to start the motion with actually showing the relevant sections of the police video, the body cam video, if it is acceptable to the court, Your Honor.
Go ahead.
All right. Your Honor, can you see my screen?
I can.
All right, perfect.
I'm not going to watch 32 minutes of this, so.
Yes, Your Honor, you don't have to. I'm going to actually go to where it needs to go, right over here, Judge.
Can we talk, sir? I need to speak with the police officer. Is that okay?
Your Honor, can you hear the folks talking in the video?
I can.
I'm sorry. You just arrived. Okay, great. Thank you, sir. Right. Can I have a moment with him? I need to get his. I need to get his version of what happened, and I'll take care of everything. Okay. Yes, sir. Hi. What happened?
I ran the light.
Okay.
Simple as that. I ran the light.
Where? What happened?
Right here. So right here, she's traveling westbound on Jackson. I'm traveling southbound on
Okay.
St. Paul. I'm coming down.
What lane were you in?
I was in the middle lane.
Okay.
I was in the middle lane, and I simply did not see it.
You didn't see what?
I didn't see the traffic light.
Okay.
I didn't see the traffic light, and by the time that I did see it. Her car was intersecting me, and I struck her vehicle on the left driver's side. I mean, on the passenger side. And then her vehicle, my vehicle went this way. I was sitting on the brakes, but there was nothing I could do.
Okay.
And my
Did you hit the
vehicle-
pole or anything?
I don't think I hit the pole, but at the same time, I have damage here, and I hit her up front, but I didn't necessarily spin. I just kind of went this way. I don't know where this came from. It must have been from her car.
Well-
I think it was the second collision, but I didn't hit the
All right,
pole.
I haven't seen her car yet,
I
but
didn't hit the pole.
if she's going this way, you come in this way.
Yeah.
It could have been that you hit this way and double impact.
That's exactly what happened.
Okay.
Yeah, I went this way, like this, and she went this way, and then
All right.
she turned all
Let me get your driver's license and insurance.
Your Honor, do I have permission to remove the video?
Yeah, go ahead.
Your Honor, thank you.
Unless there was, Ms. Rima, was there anything you wanted to show off the body cam video? Ms. Rima, are you there?
Sorry, I muted it. No, Your Honor, I don't have any questions or anything to state regarding the video.
Ms. Rima, let me just ask this. I mean, I think this is pretty compelling testimony. Do you want to just stipulate the liability?
Well, so, I mean, he's stating that it's just to the two elements, duty and breach, but, I mean, negligence is duty, breach, and causation of damages. And just because of the occurrence of an accident or a collision itself is not evidence of negligence. And I know plaintiff's counsel indicated that contributory negligence was removed, but we have included a general denial, and the courts have been very clear that a general denial, plaintiff.
Trust me, I've been doing this a long time, and so I get what you're saying. I'm just saying that's pretty compelling testimony. I mean, I've never seen anyone try to use a body cam before in a car accident case. This doesn't seem like it's a big one. Your client comes out and admits he ran the red light, and I mean, a lot of times these kind of cases just get tried on the issue of damages. That might be in your best interest as opposed to trying to fight liability, but that's
I mean,
my only thought.
I mean, my client testified that he didn't see the light and it's raining that day. He braked as hard as he could. So there's the facts show that he tried to act as a reasonable driver, and it becomes a fact issue of whether the driver's conduct was negligent. And I understand about stipulating, but the thing is, I mean, it's not just ordinary care, it's also to the causation of damages. And there's issues of whether there was causation of damages here.
Well, I'm not saying you should stipulate the causation. I'm just saying you stipulate as to liability. We just try this on. Did this, I guess, the way I've seen this done in the past is people just stipulate to liability, and we have one question on damages. And I mean, I guess you can try to fight liability on this. It might make people mad if you do that, because it sounds pretty compelling what your client said. I think it's pretty effective, but I mean, I will also say that I almost never grant these motions because I think there's usually going to be a fact issue. I guess you can make up, but I don't know that I've seen this compelling a testimony very many times with the body cam. And so my suggestion would be maybe just stipulate to liability and try this on damages, but it doesn't mean that you stipulating as to damages or that the damages were caused by the accident, but just, that question says what damage was caused by the negligence of the defendant. You still have causation in the damages question.
And yeah, and I understand that, Your Honor, but I feel that it's in the better interest of my client to go into trial with the jury getting to determine negligence first with the consideration of whether there's causation. And as far as the
Your Honor, may I just show the
strategy for the
statute? I think that
defense.
would resolve the case in terms of the duty and the breach.
Show what?
If I can just, we've cited to the Texas Transportation Code. You already know the law. The law is not if you see the light, you stop. The law is you shall stop at the red light. And then, so the gentleman in this case, and he is a gentleman, I mean, I don't have anything against him. He ran the light, and as soon as he entered the intersection, he realized that he ran the light, and he tried to make a last-ditch effort to avoid the accident. but that does not negate the duty to stop at the light, which, by the way, Judge, I took him back to the previous light. So he was stopped at the other street before this street. In his deposition transcript, which I've attached, I asked him, can you see that light? Because I showed him the Google map. The lights are visible from the prior light, and I walked them through the whole streets. The lights are there. Somehow he did not keep a proper lookout for the lights. He missed the red light. He entered the intersection, which he knew was there. And he made a last-ditch effort to attempt to avoid it. If you saw in the video where he admitted to running the light, there is actually compelling evidence of where the damages are. So it's not like his vehicle barely entered the intersection. He actually ran through the intersection, and my client's car is all the way on the other side of the street. And they hit twice in the front and the back. And so the facts, and then he admitted in his deposition that he ran the light. He admitted that it was his fault because he ran the light, that my client, that he had no evidence and he had no contention that my client had any fault in this. He admitted in a point blank. To his insurance company, he admitted that he was at fault and that he was liable. He then told my client in the text message, which I've attached, that I told my insurance company, that I'm fully liable for this. And so it seems to me that the client himself is not fighting the first two elements. And the only defenses that they have, Judge, is as to the damages.
Your Honor, when evidence shows that.
We are okay with respect to, we understand that the issue of causation, they can go in there and argue that it was not foreseeable that, someone would be at an intersection at a red light if you run a red light. And so therefore he should not be, liable, or that the injuries were not caused. We understand that part. And the damages. We're simply seeking an order as to the duty and the breach, and they have made no actual arguments as to the duty of breach, duty and breach. The cases that they've cited to, and everything they argue, in fact, the main case all is as to the proximate cause, which is the causation part.
I just want to point out that the question on damages says, what sum of money paid down in cash would fairly and reasonably compensate plaintiff for his injuries, if any, that resulted from the occurrence in question. You can always have the proximate cause question in there. I
understand that, Your Honor, but it says the courts have made it clear when there's evidence that shows the driver exercised some care, it becomes an issue of fact as to whether the driver's conduct was negligent. And I know plaintiff's counsel hits on fault, responsibility, but we all know that there's a difference between fault and responsibility and negligent conduct.
Okay. Your Honor, may I respond to that?
And there's even cases that say a driver's failure to yield the right of way does not give rise to negligence as a matter of law. Rear-ending someone does not mean negligence as a matter of law, a mere occurrence of an accident. So,
Your Honor, that's very simply resolved by looking at the statute. An unexcused violation of the statute is negligence, duty and breach.
it's negligence per se, correct?
Negligence per se. He violated.
Ms. Rima, he'll get a negligence per se instruction probably in this case. I don't think this is probably something I could grant a summary judgment on. Is this a good tactic that you're using, as I guess, and that's, it's your case. And so I'm not going to force you. And I do think you're right on the law that I can't grant a summary judgment on this, but there's a chance I'll do a negligence per se instruction. And I'm going to let the body cam in all likelihood, as well as, your client's previous statements. Is it really worth it to fight this? I don't know.
I understand, Your Honor, and I'll definitely bring that to I'll consider the negligence per se, and we are trying to get this case settled.
Well,
I'm
the problem also
hopeful.
is that we deal with all states, Your Honor. So if the issues are not resolved, and, then there's probably not going to be a settlement, and we will try this.
I mean, we're not that far in trying to settle this case, to be honest, so.
When is this case set for trial?
Um,
7/27. Let's talk about that. So we have these dockets in June and July that are, we only get one, each court gets only one trial setting a month. Do y'all want to move? When was this case filed? It's a pretty new case. I'm not opposed to moving this up to the 19th, July 19th, and trying to try it then if you guys want to.
I'm actually called in another court for July 19th.
Which court?
It's Tarrant County. I just got the setting. I had a conference with the judge this last week. I can tell you which court specifically. I'm set for July 19th in the 96th Court of Tarrant County. And then let me check my schedule. In that case is a liability denial, so it's for sure going.
Mr. Hashimi, if you want to, I'll set it on the 19th if you want me to. There's going to be a lot of cases set then, or we can just, it's not going to go to trial on the date that it's set because I'm not going to be able to have a jury that day. So I'll set it on the 19th. Ms. Rima can move for a continuance or whatever closer to the date of trial. But I do think this case should settle and they should stipulate the liability. So if you want to go to trial on the 19th or be set for trial on the 19th, we can do that if you'd like.
Yes, Your Honor. I'd like to, we'd like to be set on the 19th.
Guillermo, can you go ahead?
Part of the strategy, Judge, is just like you, our dockets are full because, since, we do a lot of personal injury cases, and since there has been the COVID-19 situation, there's a lot of cases that are stacked, and insurance companies are obviously not paying because they know there's no trial. And so I've got a bunch of trials and trying to shorten them by filing these motions and getting rid of issues that are so obvious.
It doesn't do us any good, though, if I grant motions that I'm going to get reversed on. I've learned that with 15 years of doing this. So I get what you're saying. That my best way to help you is to get cases set for trial. And so I'm going to set this on July 19th. There'll be a pre-trial on this for the Thursday before, which is July 15th. So you'll need to have everything ready to go on July 15th. In terms of have your motions and limines, your exhibits, the pre-trial will occur that Thursday before, not on the day of trial, because we're going to have so many cases set that date. And so we're not doing any pre-trial matters on the day of trial. We're doing it the Thursday before. The trial will be in person the Thursday before. The pre-trial will be via Zoom. But make sure you have everything prepared.
Okay.
Any questions?
No, Your Honor.
No, Your Honor.
And good luck. Have you been to mediation on this already?
Honestly, Your Honor, the claim rep's reevaluating it, and I'm going to be pushing with the things that you indicated, and I do think we're going to settle it. So we should know by next week.
No, I need Rhonda. Okay. All right, we'll set this on July 19th. Good luck on getting it settled, and be ready for the pretrial the Thursday before, okay?
Thank you, Your Honor.
Thank you.
Thank you, guys. Bye-bye.
Thank you.
Bye.
Hey. Okay, so I've noticed we've had a few cases that I thought we'd set for trial that they said they haven't got notices on. Are you a little behind on notices, or?
No, it should be all caught up on those.
Okay, so we're setting this one for July 19th.
Okay.
That's one of the special dates that'll have the pretrial the week before. This is an order for you.
Okay.
And then I think I printed out another order, but I never got it. Did you get any more orders for me?
From this latest case.
No, a couple of cases before.
No,
Just check through your stuff and make sure that you didn't
Get it set up.
accidentally get an order.
Okay.
Okay. we're going to be leaving in a few minutes. Lisa Blue is going to be coming here. She's going to meet with Chris, and they're allowed to use my chambers or the jury room, whatever they prefer.
Doing the orders that I have already for you? or-
Yeah, go ahead. I'll do those later. Okay, guys. Any questions about today? Ashala, you're supposed to be there at 2:00 for the Trial Skills Boot Camp meeting.
Okay.
Since you're the only one virtual, so you'll be attending that at 2:00. Unfortunately, the thing at Lisa Blue thing, you're not going to be able to go to. Do you already have the link for that? I sent it to you, I think, a while ago.
Okay, yeah, I just looked, you did.
Okay. Any questions? Tony, we'll see you next Monday.
Be my-
Rob-
Have a good weekend, everybody.